Good morning, honorable members, our legal team, and our officials, our legal teams, both from the affected members and our initiator. I welcome you all members to the resumption of the hearing, which started on Monday, the 11th of December, 2023. I just want to check whether there are any apologies from our staff. Do we have any apologies?
We don't have any apologies, Chair.
Thank you. In the absence of apologies, I now request the initiator to make her closing argument. She has 30 minutes to do so. Over to you, initiator.
Thank you,
Advocate
Chair.
Gordon.
Thank you, Chair. Chair, I will start off by just referring to section 13 of the Act. This is section 13 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, number 4 of 2004. I will read out section 13, conduct constituting contempt. A member is guilty of contempt of Parliament if the member A contravenes section 7, 8, 10, 19, 21, 1 or 26, B commits an act mentioned in section 17, 1A, B, C or 2A, B, C, D, E, C willfully fails or refuses to obey any rule, order or resolution of a House or the House, or D, commits an act which in terms of the standing rules constitutes Roman numeral 1, contempt of Parliament, or Roman numeral 2, a breach or abuse of parliamentary privilege. Chair, in terms of section 13A, sections 19, 21 and 26, well, more 19 and 21, does not concern this hearing. They deal with unauthorized publications and broadcasting. So that is not relevant here. I ask that the committee and you, Chair, read section 13 together with section 7 of the Act and sections 12 of the Act. Section 12 deals with the disciplinary action against members for contempt. But insofar as the charges are concerned, and the discharge of the onus upon me as the initiator, section 13 is then the relevant section. I will then just proceed to my further oral submissions. Chair, the charges against the members are the following. Charge 1 is common to all 3 members, save that the contravention of Rule 69B and Rule 69E of the National Assembly rules have been included in the charge sheet of Mr. Paulson. Rule 69B, as you know all too well, deals with the physical intervention or obstruction of any member or staff member. 69E is the reference to using or threatening violence against a member or other person. So these have been added to charge number 1 for Mr. Paulson, but all the other contraventions are common in all 3 members for charge 1. And before I go any further, I wish to make it clear that I do not pursue a charge that Mr. Paulson threatened violence against the PPS officials. Chair and committee, you will recall that on Tuesday, during cross-examination of Mr. Paulson, I pertinently put it to him that I will not rely on that part of section 69E which deals with a threat. Then the members have also, they also have additional charges specific only to their conduct. In relation to Mr. Tkeza, charge 2 is that he disregarded the authority of the chair and was asked to leave the chamber. We all know from the video footage that he refused, and then the sergeant-at-arms was instructed to remove him. He refused, which then compelled the speaker to call in and instruct members of the Parliamentary Protection Services to physically then remove Mr. Tkeza. He also failed to act in that he acted in breach of sections 13C and 13D of the Act when he refused to leave the chamber. You will recall that I put it to him that those were further contraventions of the National Assembly rule. In relation to Ms. Menti, and specifically in relation to charge 2, Ms. Menti persisted to speak while the speaker addressed the House and refused to leave when ordered to do so by the speaker. She was compelled to call, this is the speaker now, the sergeant
They're
at
withdrawing the
arms.
charge. They say I threatened. They are now just you.
Sorry, Madam Chair. It
Who's-
seems that Mr.
who's
Paulson
speaking?
interrupted.
Honorable Paulson, can you be orderly, please? Please. I'm requesting you to do that. Initiator, please proceed.
Thank
Chairperson,
you,
my
Madam Chair.
apologies.
In relation to
I
charge
thought-
2, Ms. Menti persisted to speak while the speaker addressed the House and refused to leave when ordered to do so. She was then, that's the speaker, compelled to then call the sergeant at arms to remove Ms. Menti or to ask her to leave. We know that she refused and that the speaker was also compelled to call in the Parliamentary Protection Services to physically remove her from the chamber. Charge 2 also alleges that Ms. Menti acted in breach of section 13C and 13D of the Act when she refused to comply with the speaker's orders to leave. There is a further charge, and that relates to charge 3, where she refused to withdraw disturbing and or threatening and or unparliamentary remarks that she made to Ms. Mgweba when ordered to do so by the speaker. She was ordered to leave the chamber for disregarding the authority of the chair, and we know that she refused to do so. That is not in dispute. The sergeant at arms was called or instructed to ask her to leave. She refused, and the speaker was compelled to invoke Rule 73(2) to call in the PPS to physically remove Ms. Menti. And then in relation to Mr. Paulson, in relation to charge 2, was that he hindered or obstructed the PPS officials from executing the physical removal of Mr. Tkeza. This was, I submit, a flagrant breach of Rule 69B and or Rule 69E, and then also Rule 73(5) of the Rules of the National Assembly. And then I now briefly turn just to summarize just the most relevant parts of the evidence. Chair and committee, we rely on the video footage of the proceedings in the National Assembly on 30 August 2022. We rely also on the Hansard unrevised transcription, which is the verbatim transcription of what was said in the House on the day. We also rely on Mr. Kaso's evidence. You will recall that Mr. Kaso was present, personally present, in the House on the 30th and personally observed the conduct of the affected members. And then we also rely on the affidavits which we have submitted into evidence. Now, just to confirm that my learned friend did say up front, I think before the commencement of the hearing, that they do not object to the admission of the affidavits for the technical, where the technical evidence is concerned. However, they do not accept the affidavit evidence of the Parliamentary Protection Services as they wish to test their evidence. My learned, I hope that I have accurately captured the position of my learned friend, but I'm sure that if I am wrong, I apologize, but if I am wrong, then I'm sure he will rectify me during his address to you. With the result, committee, that all the other evidence on affidavit is then submitted with no objection. And I respectfully submit that the committee is then, or can then, rightfully rely on that affidavit evidence to the extent necessary. Now, although the members gave evidence in their own defense, their evidence committee and chairperson does not at all disturb the evidence led by myself as the initiator, as assisted by Advocate Magona, namely that Mr. Kaso, the Hansard description, and very importantly, the video footage, which really speaks for itself, what all of those evidence confirms. The committee is obviously able to very easily arrive at its own conclusions from the video footage alone. It was abundantly clear that members, the affected members, Mr. Treza, Mr. Paulson and Ms. Menti, caused and contributed to a huge disruption and disturbance in the National Assembly on the 30th of August. Their behavior was sufficiently bad for the Speaker to instruct them to leave, which in actual fact they refused to do. It is also clear, Madam Chair and Committee, that they blatantly disregarded and disrespected the authority of the Speaker when she made certain rulings and when she ordered that they leave the House. Now, I just want to pause in summary, or to summarize the evidence really of the individual members. I will not be long, Committee. In relation to Mr. Treza spoke without even being recognized, and he raised the issue of Phala Phala. He insisted that the issue of Phala Phala is dealt with immediately. And Chair, during the course of cross-examination, I made reference, extensive reference to the Hansard description, to which I refer you to again. And he raised, Mr. Treza, the issue of Phala Phala in circumstances when the Speaker made it very clear on more than one occasion, as can be seen again from Hansard and the video footage, that it was not the question that the House was dealing with at the time. They were still dealing with the first, or maybe they touched on the second question. But she made it clear that there was an order paper and that the questions were arranged in order on the question paper, and that the members who raised the Phala Phala question would have an opportunity later on in the proceedings to raise that question. However, certain members of the EFF, including Mr. Treza, did not respect the Speaker's ruling and her direction, and repeatedly raised the issue of Phala Phala. And so did Mr. Treza, which then led to the Speaker making a ruling that he should leave the House. Rightfully so, I submit. So my respectful submission is that Honourable Treza clearly defied the Speaker and disrespected her authority. She correctly asked him to leave. He refused. It's not in dispute that he refused to leave. It is also not in dispute that he was defiant when the PPS came in to execute his physical removal. In relation to Ms. Menti, I refer to the video clip, and I also refer the committee again to pages 388 to 392 of the Hansard transcription, which clearly shows Ms. Menti's blatant defiance and disrespect for the Speaker. The record shows and the video footage shows that she blatantly refused to withdraw her remarks. Hansard clearly shows that she acted, in my respectful submission, willfully, as she repeatedly refused to obey the Speaker's instruction. On page 388 of Hansard, Ms. Menti says very defiantly, "I will not withdraw." Committee and Chair, I wish to remind the committee that Ms. Menti never once denied in the House on the 30th that she made the remarks that she was accused of making to Ms. Magweba. Not once. It was only later on in the proceedings, and after the Speaker repeatedly asked her to withdraw, that she opportunistically told the Speaker, "What must I withdraw?" Page 390 of Hansard shows, and this is what I quote in inverted commas, this is what she says to the Speaker. "Secondly, she threatened my member. I must sit here and be quiet while my member is threatened." That is what she said. Committee, this strongly suggests that she said something to Ms. Magweba. However, when the committee asked her, Ms. Menti, to take the committee into her confidence and to share with the committee what in fact she told Ms. Magweba, or what the remarks were that she made in the House, she blatantly refused. So, in my respectful submission, Ms. Menti's defiance continued even in this hearing. She refused to take the committee in her confidence. On the contrary, what Ms. Menti sought to do was to deflect away from her conduct, and her approach was rather to say, "But there is nothing on the Hansard that reflects what I said." Page 391 again shows her willfulness and defiance when she refused to withdraw her remarks. In relation to Mr. Paulson's conduct, committee, the video footage again speaks for itself, and the committee can draw its own conclusions and inferences of what you are able to see on the video footage. The video footage shows that Mr. Paulson not only physically obstructed the PPS members from removing Mr. Treza, but that he also physically pushed the PPS officials back and tried to push them out of the way. Mr. Kaso was, in my view, still being kind to Mr. Paulson in his evidence when he testified that Mr. Paulson had tried to stop the PPS in an unfriendly manner. With respect, committee, it went far beyond just an unfriendly manner. We must, however, call Mr. Paulson's conduct for what it was. And committee, you will be reminded that when Mr. Paulson gave evidence, both in cross-examination and in re-examination, more in re-examination, Mr. Paulson was blatantly defiant even to these proceedings. In actual fact, his words were, and both my colleague and I tried to take it down word for word, but the essence of his evidence was, we had to defy. Defiance was the only way to go. It was the only answer. So Mr. Paulson clearly admitted very freely and with no restraint whatsoever that he openly defied the speaker. The excuse or explanation that was given by both Mr. Keza and Mr. Paulson as to why they refused to leave the chamber or the house and why Mr. Paulson stopped the PPS is, with respect to both of them, contrived. They both testified that they were waiting for Mr. Malema's engagement with the speaker to finish on the issue of a warning. Mr. Paulson testified that he first wanted confirmation that of Mr. Malema's engagement with the speaker, where Mr. Malema called for a warning first. He wanted that engagement to be finished, and in the words of Mr. Paulson, he wanted confirmation that Mr. Keza should have been warned. However, committee, the chair shows that there was no such engagement whatsoever. The record does show that there was a continued and persistent defiance of the speaker, which only created a further disruption and disorder in the House. Chair, you will also recall the evidence of Mr. Kaso that the speaker is not at all obliged to first warn a member that they are going to be removed. There is no such rule that exists in the National Assembly rules. I wish to point out that Mr. Tabelo Malimi, who is the acting Sergeant at Arms, has confirmed in his affidavit that the speaker instructed him to ask Mr. Paulson to leave, and when Mr. Paulson refused to leave, the speaker then called in the Parliamentary Protection Services to remove him. I also reminded the committee that his affidavit is now on the record and has been accepted by the EFF's legal team. It is our respectful submission, committee and chair, that on the evidence of Mr. Kaso, the video footage, and the Hansard transcription and the affidavits which have been submitted, that the affected members impeded the function of the National Assembly on the day in question. They undoubtedly caused and or contributed to the disruption and very serious and grave disorder in the House. They certainly took part in the disturbance. The disturbance and the disorder, from what we heard in Mr. Kaso's evidence, it delayed the proceedings for almost an hour. On the facts, the members deliberately took part in the disorder and in fact aggravated the disorder, which was seriously detrimental to the decorum and dignity of the House. You will recall, as I have said previously, perhaps it's worth repeating, that the business of the House could only resume after almost an hour of the disruption. We accordingly ask committee that the members be found guilty of contempt of Parliament as contemplated in section 12, read together with section 13 of the Powers and Privileges Act. Those are my submissions, and I would like to reserve my right to reply to any submissions which my learned friend seeks to make and which I already have not dealt with in these oral submissions. Thank you, Chair.
Thank you. Initiator, let's proceed. And I will now allow members of the committee 15 minutes to ask only clarity-seeking questions to the initiator. Let us show this by a raise of hands, honorable members. Honorable Mlenzana, you are the first. Over to you.
No, thanks. Thank you, Chairperson, and good morning to all, both at M46 and the platform. Chairperson, whilst appreciating the presentation, mine is just but one question. During the course of the proceedings, the initiator would recall that in the statements which were filed, there was also element of the regard, in fact, the high regard of the invitees, the guests who were part of the occasion that was actually jeopardized. Now, what does that say to the onlookers, those who were watching outside Parliament, going even abroad? And two, the initiator also mentions not but once the fact that the time which was scheduled for that session had to be delayed by almost close to an hour. Now, in rands and cents terms, in monetary terms, how can she perhaps relate to that delay in terms of the costs that were incurred by both Parliament and the guests and whoever was watching the jeopardized occasion? Thanks, Chairperson.
Thank you, Honorable Mlenzana. Honorable Deputy Chief Whip, number 2.
Honorable Chairperson, I'm sorry I don't have a clarity-seeking question. Thank you.
Thank you, Honorable Deputy Chief Whip. In the absence of other hands, I will now invite, I will now request the legal representative of the affected members to make his closing arguments. He has 30 minutes to do so. Over to you, on
Sorry,
the
Chair, am I not required to respond to the committee
Okay, sorry,
members' questions?
sorry, you are required to respond because they will ask clarity-seeking question to advocate after his closing arguments. You may do so.
Thank you, Chair. In relation to the first question, the impression that the disorder and disruption created with the guests and outsiders, and also even it was obviously accessible and broadcasted on YouTube. It was live streamed on YouTube, so that means anyone could have watched it anywhere in the world, and I'm certain that did happen. Certainly, there were thousands or hundreds and thousands, if not millions, of people who watched the broadcast on that day on the television sets. So, committee, it obviously created a very, very bad impression of the South African Parliament in general, that it is beset by disrespect, disorder, and a disregard for the presiding officer who was the speaker. So it made a very, very bad impression all around. The fact that the proceedings were delayed, and that I will try to answer question number 2. The delay of the business of the House on that day obviously had some repercussions for the House itself, because it could not continue with the business of the House as it was scheduled to do. And the business of the House is obviously an obligation of Parliament in order to execute its function, its duty, and its role to the people of South Africa. So that, in my respectful submission, is quite a serious repercussion or consequence. The committee member also asked me to comment perhaps on what the costs would be, or repercussions relating to costs in rands and cents, which may have been incurred in relation to the delay, or which was caused by the delay. I am unfortunately not able to meaningfully comment on whether it had a monetary effect or whether there was wastage of costs, because I don't have that information. However, I would like to say that it was serious enough that the disturbance and the disorder in the House created a delay, which meant that the House could not perform its function as it was required and obligated to do in terms of the Act, and also for the people of South Africa. The disruption certainly also caused the delay certainly also impacted all the citizens of this country who had made time in their day to watch the proceedings as it was live streamed. Thank you, Chair.
Thank you, Initiator, for the response. I will now request a legal representative of the affected members to make his closing arguments. You have got 30 minutes to do so, Advocate Kasibote. You may start. Thank you.
Thank you, Chairperson. Can I please, just before my time starts running, address this issue, if you don't mind, Chair? It's an issue that has nothing to do with my submissions, just a question of procedure. So I ask that the time don't start until we resolve this aspect. The initiator has suggested that she is reserving her right, she calls it, to reply. This is no different from a trial I submit to you, Chairperson. I accept readily, and I did not contest it, that at the stage evidence is being led, of course, you lead your witness in chief, then there's cross-examination, and then there's re-examination. So I don't take qualms with that aspect. What I certainly take qualms with, certainly in terms of natural justice and how you typically run trials, which is in essence what we're doing here, you don't have a right to reply in submissions. And I'm suggesting to the chair that it would be grossly unfair to have the initiator address this committee, which she has for 30 minutes. She's got a second bite to address the committee as she has now. She then has a third bite in reply to address the committee again, when all I have are the 30 minutes that have been given now. I mean, there just can't be justice in that. I'm suggesting to the chair that you give us a ruling on this. My suggestion is, as you run trials in the ordinary course, there is no right to reply to submissions. What she has already is a second bite at the cherry, which goes beyond the 30 minutes she was allocated when responding to the committee members, and she'll have another one later on. And I'm asking, Chair, that no such right exists, and that you rule on that. Thank you, Chair.
Thank you, Advocate. Your concerns are noted. My understanding is that, Advocate, if you are given 30 minutes according to the schedule, if you still have got something to say beyond that, you have got those rights to request from the chairperson, and no one is going to deny you that, even more than that. And that's what I was always doing. On issues of time, to both of you, special to yourselves, I wanted to make sure that I don't deprive you because you are defending the team. So may you please start.
No, sorry, Chairperson. My concern goes beyond the time allocation. I accept that at your discretion you can give me more time. I'm dealing with a principal issue. I'm not dealing with time, Chairperson, with respect. I am saying to you, the initiator has made her submissions, and I'm going to respond to them. If she's given a right to reply to submissions, an unprecedented occurrence, what she might raise in submissions, I will not have an opportunity to respond to. So whether I have 45 minutes now or 30 or 2 days is of no moment, because my concern is not a timing issue. It's an issue of you do not make submissions and reply as a matter of principle. And that's the concern I'm dealing with, Chair, with respect.
Thank you, Advocate. You can advise so that I don't deprive you anything. If you want to maybe respond to what she has responded, you may do so, because I think your concern is that I shouldn't have given her, but according to my schedule, that's how the program should run. So if ever you have got something to say, because yours is to deal with your closing arguments, and in that order, you may add what you wanted to add, because the platform is open for you now.
Thank you, Chairperson. I don't want to belabor the point, perhaps in assisting the Chair in making a finding in this respect, because I feel very strongly about it, I must say. If you have regard to number 5, to the schedule, to the rules, it says what the initiator may do at this point. And it merely says she may address the committee, including on sanction, and that is what she has done. And then it says we have a right to respond to it, and that's what we intend to do. There's no provision anywhere that she can come back and have a second bite. It's not even a second bite, it will be a third one, because again, unprecedented, she's been allowed to address the committee again on 2 occasions. It's just unprecedented, it's unfathomable. And I'm asking you to make a ruling on it, Chair, in relation to the schedule that I've referred to you, which is Schedule 5 specifically, and then direct me as to where the initiator has that right. With that being said, Chair, you can start my time.
Advocate, let me allow my legal team to advise, and I don't dispute that, but what I was saying or asking from your good self is whether you want also to respond to what she has responded. If you may clarify me on that, because already she has been given that opportunity to do so, and moving forward, so that if that should not be allowed, we correct it. I don't want you at the end of the day to say that the processes were not unfolding properly. I'm giving you that opportunity.
Sorry, Chair. Sorry, Chair. I'm sorry for
Yes.
interrupting. I'm really sorry. Chair, can you stand down for just 5 minutes so that your legal team can advise you on this issue?
Yes, thank you. Let's wait for 5 minutes and then we'll come back with due respect. Thank you.
Recording